Hi, I'm Jennifer McGuinness, a Senior Associate here at Myerson in our Contentious Probate Department, and I specialise in helping people challenge and defend wills. There are two main ways that wills are challenged. The first is on the basis that the will is not valid, and the second is to challenge the will under the Inheritance Provision for Family and Dependents Act 1975. So let's look at the first way to challenge a will. Validity is the first way to challenge a will, and the most common validity challenges are as follows. Firstly, if the will is a forgery or created by mistake, if the person making the will lacks capacity, or if the person making the will has been put under undue influence by a beneficiary or other person. If the claim is successful, the estate will pass pursuant to any earlier will, if there is one, or under the intestacy rules if there isn't. The intestacy rules are set out in the Inheritance and Trustees Powers Act and determines who inherits what based on family connections. The rules don't take into account the closeness of your relationships or who is most in need. There is no strict time limit for these sorts of claims to be pursued, although delay can often cause problems. So if you do think that you have a validity claim, then we recommend taking early legal advice. And of course, we're here to help you with that. The second route to challenge a will is pursuant to the Inheritance Provision for Family and Dependents Act 1975. Certain categories of people are able to bring a claim for financial provision to be made for them out of the deceased's estate. The categories of people who can bring these claims are as follows. Firstly, spouses and civil partners. Second, children, including minor children and adult children. Thirdly, anybody treated as a child of the deceased, which might include a stepchild. Fourthly, cohabitees. And fifthly, anybody else who is financially maintained by the deceased at the time of their death. Spouses and civil partners are not limited on what they can claim from the estate. The usual position is that they can recover what they might expect to receive if their relationship had ended in divorce or their civil partnership had been dissolved, rather than that relationship ending in death. This usually means that half of the matrimonial assets would pass. In the cases of all other applicants, they can only claim what they need for their maintenance. It's not possible to claim for what might be considered to be fair or right. Maintenance only covers everyday housing and living expenses at the usual and expected standard of living for the applicant. The time limits for these types of claims are quite tight, and we therefore recommend taking very legal early advice. So this has been a very quick summary of the two main ways to challenge a will. If you would like to speak to me, or indeed any other member of our specialist team, about potentially challenging a will, or if you are an executor who has received a challenge from a third party, then please do not hesitate to get in contact with us on 0161 941 4000, or you can email us at lawyers@myerson.co.uk.